Obviously, we were trying to assemble a lot of folks on a very short time frame. It is my distinct pleasure to join the Minority Leader, Themis Klarides, to the press conference. Normally, I do this with Matt Ritter, but I had...
He got smart and traded up.
Matt, if you're watching, I did not say that. But we really wanted to bring folks together to talk about House Bill 5001, which you're all well aware that the governor vetoed, and that we're planning on taking up a veto override on Monday. And explain a little bit about the bill and have some folks that have experience with the implications of what we were trying to resolve with the bill. I think there's a lot of confusion. Unfortunately, the labor unions have sent letters opposing the veto override and asking members of the General Assembly to sustain the veto. My personal opinion, I think that's a mistake, and they don't know enough about what this bill and what the lawsuits, more specifically what the bill is trying to rectify, is doing to small businesses here in the state of Connecticut, specifically restaurants. The Department of Labor, with its regulations, was advising the restaurants to follow what they call as the 80-20 rule, which is that tipped workers cannot exceed more than 20% of their work at a time period doing non-tipped work. Department of Labor was saying, nope, just stick to the 80-20 rule and you'll be fine. They did it in printed guidelines that was available on their website up until 2018, and the restaurants followed those laws, those regulations, and lo and behold, a certain law firm here in the state of Connecticut started filing both class action suits and individual suits, and these restaurants are seeing astronomical lawyer fees, astronomical cost going to, quote, plaintiffs that were actually recruited by this law firm. And we, as the General Assembly, tried to step in and make a terrible injustice caused, in my opinion, again, by the Department of Labor, make it right for the small businesses, the restaurants in the state. I was extremely disappointed that the governor vetoed the bill, and immediately the Minority Leader and I got on the phone and had started having discussions about our intention to override that veto. So obviously the people are here to speak more specifically about the bill and give you real life situations, but at this time I'll turn it over to my good friend and the Minority Leader, Representative Klarides.
Well, thank you, Joe. And as the speaker mentioned, this is certainly a bipartisan effort here. I know the speaker and most of his caucus and our caucus, and I know the Senate Republicans are also in support of this override on Monday. I know that the restaurant people in this room understand how this works, but just for the reporters, to try and make this as simple as possible, when you're a server or a bartender, you don't get the regular minimum wage in the state of Connecticut. That has been our existing law, and it continues to be law. You get a tip credit because you get tips. And so that reaches the minimum wage, and most oftentimes more than the minimum wage. But oftentimes as a waitress, you're going to have to do things within your job description during your shift that does not require serving food or serving drinks. They can give you tips, like filling the ketchup bottles, like filling the salt and pepper shakers. And when you do that, that is usually in an intermittent way. So when you do that, that could take 4.5 minutes, and then you go back to serving food, and then you can come back out and say, oh, the ketchup's not full here, and that could take another 1.5 minutes, and you're not serving food. So when we talk about the 80-20 rule, what the Department of Labor in the state of Connecticut has said in writing, on their website, and to the faces of restaurant owners when they do audits of their businesses on a regular basis, is you do not have to articulate or enumerate every second of time when a server doesn't serve. As long as it is less than 20% of that shift, you are completely comporting with our legal requirements, and you are legally within reason, and you are doing the right thing. That is what every restaurant owner has been told in the state. So they were following the rules as they have been told. Now there are lawsuits going on, and those are a result of the Department of Labor and what they're telling business owners. So the fact that you're being sued for something you were told you needed to do is preposterous. We got together, we sat down during session, and we said, Department of Labor, you have to clarify this. Please sit down with restaurant owners and the federal government, because their regulations are very clear on this 80-20 rule, and clarify it. That's all it said. And the governor, somehow, based on information he got and advice he got, thought that that wasn't right. Well, let me tell you something. In a session of one of the most anti-business sessions I've seen in my career, this, at the very least, needs to be done to show business in Connecticut we have your back. Because this is not an issue of business versus workers. This is a workers' bill. We have lost track of the fact that you will not work unless you have a job, and you will not have a job unless there's business. We've somehow lost track of that fact. You seem to be either on the side of business or workers. You can be on both sides. This is a workers' bill. These are small businesses that worry every week about making payroll, about keeping their lights on, about making sure people have jobs who have families. These are not the GEs of the world and the IBMs of the world. These are hardworking people like you and I, like our neighbors, who have children to maintain, who want to make sure they're treating their employees right. This is a workers' bill, this is a Move Connecticut Forward bill, and this is showing the state of Connecticut that we actually care about workers and businesses.
And I agree with almost all of her comments.
I know the one you don't agree.
That being said, I know there are specific questions. We are joined by a few people today. At this point, I'm going to turn it over to Scott Dolch from the Restaurant Association to give him the opportunity. Would you all like me to move the mics? Would that be the easiest? No, absolutely not.
Thank you.
Yeah.
Yeah, no, thank you. First and foremost, Scott Dolch, Executive Director of the Connecticut Restaurant Association. I just want to thank the speaker, Leader Klarides and Representative Tigliano for their leadership throughout this process. And I also want to thank the entire General Assembly for their support as they did pass House Bill 5001. But I can say I'm disappointed, to say that I'm disappointed in the governor's veto and the lack of support from the Connecticut Department of Labor is an understatement. As many of you know, restaurants have been operating for years under these 80-20 guidelines, as what is better known as the 80-20 rule. They've been established by the Connecticut Department of Labor, and I brought copies in my hand, a booklet from 2015 from the Department of Labor that has been on their site for years. It was created not by us, it was created by the Department of Labor Wage and Workforce Standards Division. Inside here on page 14, it clearly defines the 80-20 rule. It clearly states that if an employer is following this standard, they need not require the employee to segregate their time on a time record. However, there's obviously contradiction to that in the section 31-62-E4 in the Connecticut regulations, and that is what we have been working on really as a group to pass House Bill 5001 to get clarity and to continue to follow those same standards and procedures that the DOL has been provided to our restaurants for so many years. I can speak for all of my member restaurants in saying that we're disappointed in the comments that are being made by the DOL, as our goal as an association is to continue for restaurants to follow these same standards and policies that have been provided to us in the past. Their decision is not only hypocritical, but damaging to the restaurant community as a whole, both operators and employees, like Leader Klarides said. And it is my hope that both the House and Senate will continue to support the restaurant industry by voting in favor of an override of HB 5001 on Monday. At this time, obviously we have Barry Jesseron. He's an owner of Green Valley Hospitality Group in Putnam, Connecticut. Barry and his brother Brian own and operate Vanilla Bean, Dogleg Cafe, 85 Main and Fenton River Grill. To be able to speak a little bit as I wanted to bring a restaurateur here, to be able to speak specifically on these standards, these policies and procedures, and what they've been following and been told, not only from us, but from the DOL.
Scott, just spell your last name before he moves the mic.
Sure, Dolch, D as in dog, O-L-C-H.
Thanks very much.
Mm-hmm.
Just like it sounds.
Great, thank you, Scott. As you said, my name is Barry Jesseron. I co-own a number of restaurants in northeastern Connecticut that's all overseen by a company we call Green Valley Hospitality. The Vanilla Bean Cafe has been around for 30 years. We're celebrating our 30th anniversary this August. I've been in the business personally for almost 40 years, and in different states, and the 80-20 rule has sort of been applied in all the places I've worked. We employ probably between 140 and 150 people, depending on the season that we're in. And all of our restaurants have become great, important places in the community, a lot of places where people start their first jobs. This bill, oddly enough, I didn't even know there was inconsistencies in it because we'd sort of been following along what we thought was the right thing to do all along. It was only until we were recently sued that we found out that there was a gray area and inconsistencies that we just didn't even know about. And the fact that there's a law firm that can go after those inconsistencies and go after a small business like ours or any other small restaurant in the nation and in the state, and go with class action lawsuits is reprehensible in my opinion. We're an important employer in our state. We're important businesses in our community, and something like this could be very devastating to our business to the point that we might have to close in order to pay the potential fines. So,
How do you spell Jessurun?
Jessurun.
Thanks.
And just to add on that, and Barry's story is not different. It's all around the state. There are some large restaurants, there are some small restaurants that are current litigants. The website of this specific law firm is out recruiting and trying to find more wait staff that fall into this gray area that goes against the advice that Department of Labor gave them. And it would have a detrimental effect. So why on 5001? The beginning of 5001 was House Democrats' most important bill for the year. It was about workforce development. We spoke to Leader Klarides, her caucus. It was supported throughout. It's putting together a board of individuals from around the state, from higher ed to manufacturing to restaurants to hospitals, to allocate funds and do workforce development. So how on one hand could we be moving forward with what we believe is landmark legislation for workforce development and not include something that could have the potential of thousands of layoffs here in the state of Connecticut? If these restaurant owners are ultimately subject to these gross injustice and paying these fines and these settlements based upon DOL's bad advice, what have we really done? So that's why, in consultation with the other side of the aisle, we decided to put it on the most important bill that we thought for the year, because we think this is equally important. And there's a lot of misinformation about this. Barry, his brother, their company, they're not anti-worker, they're pro-worker. They were following the advice they gave. They employ, you just heard, many people. They sponsor the Little League teams. They do the nonprofit work in the towns. They donate their food. And these are the people we're gonna give bad advice to. And when the time comes that they're facing litigation, we're gonna say, oh, sorry, and just move on. It's just not fair. It's not fair. So 5001 is not just pro-restaurant, but also pro-worker, because the establishments will be there for the worker. And it's doing the right thing. There was a mistake made, and we're trying to rectify it. So with that,
and it's not about, it's absolutely not fair, but it's not right. You hear about all of these surveys and polls that we see about Connecticut being the bottom of the nation as far as being anti-business. And we're sitting here telling these hard-working men and women who work 20 hours a day and put their families on hold to make a living and help other people make a living, you know what? You have to listen to what the Department of Labor tells you. And now that somebody's claiming that's not right, you are now the victim of million-dollar lawsuits, multi-million-dollar lawsuits, and we can't help you.
What about, one of the governor's objections here was that there was no public hearing on this. Restaurant owners did not get a chance to come up and be heard. Labor did not come up and have a chance to be heard. You guys decided that you were gonna do this without getting public input.
Mm-hmm.
Why?
it came to us late in the session. When we became aware of it, we had about 30 days of meetings, various meetings, Department of Labor, bringing in restaurant folks to try to really understand the issue. But it was already after all the committees have completed. Is it the perfect way of doing it? No, but we do it quite often, as you know. When we see a situation, we'll do an emergency certified bill. And to be quite honest, if we did not address this and did not come to my attention during session, I would have called this into a special session and tried to get sign off for emergency certified bill. That's how important I think it was to read.
But in addition, Paul, that's why the language in the bill was as specific as it was. It directed the Department of Labor to sit down and meet with restaurant owners and the federal government in regards to their regulations and figure out a way to make sure that the ambiguity with these issues are clarified. Okay, it directed people to meet and fix this. That was the point of it. And because it came to us later in the session, that's why it didn't work the way it sometimes should work. But that was the direction of it.
Was
So-
labor at all given an opportunity to come to the table and discuss this? I mean, you said you brought in, you spoke to
Yeah.
restaurant owners.
Well,
Did you
Department of
speak to-
Labor, I
Well,
mean-
I'm not talking about Department of Labor, I'm talking about organizations that represent working people, organizations that represent unionized workers.
Yeah, so I'll be clear, I don't know that there's any union that represents the employees that are affected
Right.
by this. So I don't know how they would have a seat at the table unless organized labor just believes they speak for every worker in the whole state.
Well, sometimes.
Then
they
maybe,
do.
maybe I should have brought it in.
And they may think that, but I think that the speaker is correct. I don't think any of these restaurants that we're talking about have unionized workers. So
Well, I
it
also-
wasn't something
just-
that we thought to bring to the table because they weren't part of this discussion.
But that's why I also mentioned organizations that in their mission see themselves representing the interests of working people.
Yeah, I've offered to have the discussions. I know that they really do advocate for non-unionized workers too, but this situation is not something that the employers created. It's not something the workers did. It was bad advice from a state agency that we felt it necessary to fix. And it was that simple. So hindsight, maybe we could have brought them to the table, but we really didn't have the time. And again, there was none of the workers that were affected were represented by a union.
Why is it the responsibility of the General Assembly to fix this? Why should these restaurant owners not make this argument in court in order to fend off these private lawsuits that they're dealing with?
So that is the legal question. Ryan, do you want to come on over? Come on.
Sure.
Barry, you may be off the hot seat for a few. Trying to anticipate all your questions and make sure we have the right people.
Thank you.
Sure. Ryan O'Donnell, attorney for the Connecticut Restaurant Association. And I think with regard to that question, any judge or jury would be looking at this matter from the regulations we have right now. So they would be evaluating the case from regulations that, as the speaker noted, are unfair and frankly not right. So the idea is that rather than evaluating this case with a regulation that's patently unfair to restaurant owners, we need to take a step back and make sure that we have a fair process. And I think if we hold folks to these unfair regs, and that's the criteria for the courts going forward, then the verdicts will be unfair.
So you don't think this argument would hold up in court, so you're going to change the state law and state regulation?
If a judge is just looking what's on the books, they follow what's on the books, and what's on the books is unfair.
Speaker Aresimowicz, can you name another example where the General Assembly has revised state regulations or state law to help private companies prevail in their lawsuits?
I don't know that it's that simple, and I can't, but that's in my opinion a very simplistic view of it. We gave them the advice. It would be like us putting up a speed limit sign that's saying 65 miles an hour, and then somebody raising, oh, but there's a steep bend, all other portions of the state of Connecticut is 55, and then a cop giving the person a ticket for going 65. That's the comparable to me. It was our advice they were following, and not to step in and fix it would be rare. Do we normally jump into, quote, pending litigation? No, but I would say 99.9% of the time that we weren't the problem, right? This particular case, we gave them the advice, they followed it, and now they're legally liable. That is not fair any way you look at it.
I want to add to that. I mean, to characterize this as we're stepping in to a private litigation, I think, with all due respect, is just inaccurate, and here's why. To say that the state of Connecticut, who every business owner and every other group, right, anything that we make a law about, they have to follow what the laws. So they go, whether it's school follows what the Department of Education says, or another group follows what the Department of Public Health says. These people follow what the Department of Labor says, because that's their area in which they fall under. And so when they're following the laws as are explained to them on a daily basis for years, in writing, in spoken word, when they get their audits, etc. And then they're being sued for it. To expect somebody to pay millions of dollars in legal fees to defend something that they didn't even do wrong isn't right. I mean, it's not right. So we, as the speaker said, put forth these parameters. The Department of Labor somehow did what they did, but these people did the right thing. So it's not fair to say, okay, you know, let the courts decide it. That's one thing if lawyers were free, right? That's one thing if lawyers were free, but they're not. Thank goodness for me, they're not free. But I mean, that's not fair. You know, I mean, that's not fair, and it's not right, and it's our job as legislators to make sure the laws that we put forth are followed. And you can't have people that are doing the right thing and only following what we're telling them, say, okay, well, let them figure it out, and after they pay millions of dollars, we'll see what happens then. I mean, if that's not the most wrong thing I've seen in a long time, I don't know what is, and that's how we got involved.
Joe, Senator Looney said his caucus is still discussing this. They're probably going to caucus on Monday. If after that caucus they tell you, no matter what you do in the House, we're not taking this up, do you still plan to take it up in the House?
Yes.
Or could you just talk about why you think no matter what it has to be voted on in the House?
So I tend to get myself in trouble from time to time because I put myself out there further than anybody else in what I believe is right. And even with my friend to my left here, we disagree on transportation, but I put myself out there at political peril and otherwise, but just because I believe in my heart moving forward with tolling and everything is the right thing to do. This is the exact same thing. I am now on the opposite side of some friends I've had for many years, some to which I've had some very heated discussions. But it's not my job to sit in this seat as Speaker of the House to be liked by everybody. It's to do what I believe in my heart is the right thing. And folks can disagree with it. The governor can disagree. The labor unions can disagree. Themis disagrees in her party at times. But that's my job. So Keith, specifically, because I am willing to risk whatever political capital is to do the right thing. And these restaurant owners did nothing wrong. And every now and then you have to stand up and just take whatever punches come your way.
Do you think, though, a overwhelming vote, I mean, both this bill passed
Yeah.
by what? I think unanimous votes or maybe just a couple negative votes.
And look,
look it up. But my point being, if you guys have a unanimous vote in the House, does that create pressure on the Senate then perhaps to do things? Because sometimes, that's how this place works. Sometimes one chamber puts pressure on the other and sometimes the other, I don't want to say bends, but perhaps comes to its senses.
I try not to speak for other people, specifically the Senate or the executive branch. I've always known Marty Looney to be a man of honor, and he understands these issues, and he's going to represent what he needs to do his caucus, and hopefully they come out in the position that they want to move forward with the bill. I know Senator Fasano has weighed in, and he believes his caucus is supported. Look, it's never easy being the leader, and Marty does an incredible job, so I don't want to begin to guess what they'll talk about or how they'll do it.
Yeah, but when you pass something overwhelmingly, does that not
Yeah,
at least create some
look,
impetus, perhaps?
I don't know how
Let's
overwhelming it
hope
will
so.
be. I have a handful of my
Fair enough.
members that are not comfortable with this bill either, for whatever reason, and I still feel strongly it's the right thing to do.
I have a question for Representative Ritigliano,
Sure.
if you don't mind. I know
I don't mind.
you're a restaurant owner
We never
yourself.
mind.
I'm here to support and answer any questions, but the speaker and Themis have done an unbelievable job outlining the issues, so, and I appreciate their support.
Was the 80-20 rule something that you've been following in your business?
So-
How did you handle this lack of clarity?
So I have in my hand, and what Scott showed you before is a booklet that was provided by the Department of Labor. This booklet really just codified common practice that we've been doing for decades. And this is what we follow, and we do our best to follow it. If we run afoul of that, an employee has can address their grievances with the Department of Labor, and they can bring suit. So we've done the best we can. We don't let servers do things that aren't regular and customary to their job or service related. Cutting a lemon for a bartender is sort of part of the service experience. As long as that doesn't become their only job all day, they get the tip credit or they receive the tip wage. They're not parking lot attendants. They're not sweeping up the entire building and mopping floors at the end of the night. We're talking about filling salt and pepper shakers, filling ketchup bottles, maybe picking up something that a customer dropped at the table. All things related to service. If a restaurateur runs afoul of that or is breaking that rule, they have every right, and this bill doesn't take away their right, to bring redress their grievances. They could bring suit, they could file a complaint with the Department of Labor. Everything stays intact. So I am fully supportive of this. I really do hope we override the veto, and I appreciate everybody's support.
Are you going to participate in the vote on Monday since it will affect how you pay your employees?
Well, it affects every restaurant, not just mine, so I would think that there's no conflict of interest there at all.
Do we know how many lawsuits and how many workers are involved in these lawsuits?
That may
And
be
the impact?
I think it's about 12. I think 9 of which are currently active, and it potentially is 1,000, at least 1,000 workers. Some of them are multi-location restaurants. As Barry was talking about, his particular company has a few different restaurants. So how this has been working is it's class action. They find workers from this time period specific, and then everybody is covered by that.
Brian, do you know the exact number?
I think it's about 12.
12 lawsuits
We have a few in the room.
against
No,
12.
There's some
There are
people
some
in
in
here
12
that-
class actions.
that you
Okay.
can-
And I think some are under appeal, so there's a lot out there.
And
Just
you're
to clarify,
you're
that
comfortable
12
doing
class-
that though. I mean, you're comfortable making it retroactive so that
Yeah.
these
so-
lawsuits essentially go away.
So let's define
Well-
comfortable. I did it reluctantly.
Okay.
There was many discussions with myself, staff, Leader Klarides, talking about how we could get to that. It's not a step that we took like, hey, let's just erase it all. But when we started to dig into the facts of the matter and found out from 2015 on that they've only been following the advice that they were given, we thought it was imperative that we step forward and make it retroactive, because all those companies that are currently involved in litigation, kind of our fault, right? I mean, we gave them that bad advice, so we needed to make it retroactive.
To be clear, if they were following the rules outlined by the Department of Labor, yes, the lawsuit may go away. But if they are beyond or run afoul of even these rules, that lawsuit may stay intact. It does not absolutely absolve anybody. It would absolve them if they were following current rules and rules that they thought were provided for them for the Department of Labor.
Can we ask other questions about Monday? Or what will happen on Monday?
I have
Sure.
one
Is there
more
any
follow-up
more
question
about restaurants? Yeah.
on topic. My understanding is that the repeal of this regulation is going to create a period of time in which there is no state regulation. And so are you concerned about the uncertainty that that will create for restaurant owners when they're in a time when there is no state regulation?
Yes, we are. It's my understanding the Department of Labor has said it would take some time for them to do that. I would ask them, they got great staff, I know the commissioner, I don't know how this happened, but if they dedicate themselves to it, the Restaurant Association has already stepped forward and said they will make whatever restaurateurs available, workers available, to all get around the table and come up with regulations that make sense and is fair for the worker and is fair for the restaurant owners. So I know on that side of the issue, they're ready, willing, and able to start tomorrow to come up with the regulations. And knowing some of the staff over at DOL, if we put our mind to it, it could be done rather quickly, so the window would be small and we wouldn't be risking it for workers.
And again, that was the direction, that was the actual language in the bill.
But the federal rule still applies. They're not absolved of labor standards and practices. The federal rule just happens to be 80-20.
Yeah. Anything more about 5001? All right.
Okay. So Monday,
Yes.
will you guys be doing a school construction package? And would you at this time ratify the union agreement on the pension refinancing?
Yeah, we just got that yesterday. I don't
Right.
know that I was actually surprised when it was suggested that we may need to take action. I didn't think that we did.
I'm surprised right now.
So we're kind of checking into it. I got the press release very late yesterday, so I don't know what's gonna happen with that. But yes, school construction is ready to go. So we will convene the veto session We will do some bouncing back and forth of the rules. It's my hope to take action on 5001. It goes to the Senate and they take action. We'll do the school construction, and we'll also convene a new session to do the conveyances. There was a handful of conveyances that were not done in the Senate. It was part of the problem created by the ballot initiative is they all have to be done separately.
Joker.
So we'll be moving forward with those. To be clear though, there is no additional conveyances. They will only be the conveyances that had public hearings and were passed during the regular session. There'll be no language change, there'll be nothing. They'll be exactly as they appeared in the public
So
hearings.
this would be
And
the
for some-
Cheshire, Beacon Falls.
But for
Couple
some
for
reason,
Berlin.
the Senate didn't finish them. The
Yeah.
House, we did them, we followed all the rules, we did them one at a time, they were completed. For some reason, it got caught up in the Senate and they didn't finish them.
Joe, can I just clarify one other thing on the pension stuff? Because I guess I assumed it had to be at some point ratified by the legislature because it's a contract change, because we negotiate how we save. But I thought if a contract amendment or a new contract came down after the regular session, you could actually even do it in the next session. Like, it's like a
Right.
30-day window or something for acting.
Yeah, we altered it in the bipartisan budget to allow for them all to be voted on, which we all agree is a good thing. It just arrived late yesterday. I think they're still looking at it, but you're absolutely right. If we need to take action, we don't need to do it immediately. We can do it next session.
And the bond
we should do then.
package,
Yeah, bond package is still,
Not ready.
we're still working on it.
It's a work in progress, right?
Yeah, work in progress, yes.
Well, there was some complaints, not from the House Republican side, but certainly from the Senate Republican side concerning the development of this package. So, I mean, what is going on between Democrats and Republicans in terms of negotiating this package? Are you talking to each other? Are you negotiating with each other? Are you writing letters to each other? Smoke signals?
There's always letters.
Yes, yes.
I can only speak for my understanding of where we are in the House. Representative Miller and Representative Florin have regular discussions about what was going on. I don't know exactly how that is, if it's negotiations, discussions, but I know they talk quite frequently. And I talked to Pat Billy Miller again the day before yesterday. She says she's been talking to Libby throughout, who is Themis's bonding chair or
Right,
ranking
but there
member.
has been no conversations between us on that.
Yeah.
Will there
Myself
be-
either.
Yeah,
I haven't
no,
been any of
but
them.
eventually, would there be a conversation between the House and Senate leaders concerning this bond package at some point?
Again, you can only hope.
I know, I'm just asking.
Yeah. We're talking.
Also, since it changes so often, what is the latest on tolls?
Tolls?
Is there any,
what's the
any new
latest?
update on that?
In the last
Changes-
hour, did you change your
changes
mind?
regularly?
I'm still where
How
I
much better
look,
it is
I-
when we do this together, so then you
This
don't
is
have to
good.
do it, and they don't have to come out there and ask
Seriously,
you all the
let's go back
same
to the good
questions,
point.
you just do it all here.
I'm still where I've always been. That I think tolling is a responsible option to capture the much needed revenue from the majority of it, or at least the just short of the majority of it, from out-of-state drivers. I'm open to whatever compromise is necessary that we move forward. The longer we take no action, the worse our roads get. And in my opinion, when a tragedy happens, we're all going to have to look in the mirror and say, yeah, we should have done something about it. So I don't know that all the other proposals are really being floated just to see what the general response is. But there has been no bipartisan or partisan meetings on a whole about tolls in the last month. I think it's just different ideas floating up of what's possible and how do people feel about it.
So just to clarify, you certainly haven't gotten any specific details from the governor on the modified plan he's developing, like these bridge locations or anything like that?
Details, that's such an
No,
unimportant
please.
thing.
No, look,
Why would we wanna know details?
One of the things I do appreciate about the governor is, he does engage in multiple conversations, and he puts ideas out there, sees what the response is, and so I think that's part of the process that he's been engaging in, but there's been no global meetings, we're not all sitting down throwing around ideas.
And so anything, excuse me, anything that we may be hearing is, I don't wanna say a trial balloon, but there's no pen to paper, there's no, proposal, or is there, of these different ideas, whether we toll bridges or whatever we do?
The only thing I know of is the transportation, which is Representative Lamar and Senator Leone that came out with a tolling plan. Absent that, there is no written language or proposals that I know of.
And also on a practical basis, are we talking probably no toll action until September, or on a practical basis, as we sit here on July 19th or whatever it is, what is our timeframe?
Timeframes, you're asking me? I'm
Well,
the worst at it. I don't know. I'm here. I'm more than willing to meet and talk about any subject. So if a proposal comes out, a written document comes out, have public hearings, whatever needs to be done, I'm here.
Well, I mean, Chris, just as a follow-up to the speaker's comment, his comment assumes that tolls are the only option to fund transportation. So, of course, we would all be upset if there was a tragedy that occurred on the roads, or something happened that was because a road or a bridge was in disrepair, obviously. But assuming that tolls are the only way to fund it is just a false assumption. And so you know there are other alternatives out there. And when we heard this week about trucks only, or bridges only, or whatever it was, these are just regurgitations of old ideas that are being floated, and that's because there aren't the votes out there for the proposals that have been put forward. We still maintain the position that whether it's one toll or 80 tolls, one toll will become 80 tolls. And it's just opening the door. And it just seems to me, and we certainly agree on this policy-wise, but the reality is that we have now gotten to almost August. And when you hear about now possibly trucks only or a handful of tolls, the point here is this. They want to get their foot in the door to get toll gantries up, and then the sky will be the limit. There is no limit on it. There are no parameters to it. There is no plan. There was never actually true plans. And that's what our concerns are. That's why we still hold firmly against the toll proposals.
So you
That's
think
it?
tolls are gonna pass it?
Fully supportive. I don't know. That's what I heard. I'm putting it on the board Monday.
She was in for
I
what?
was tweeting something, so it's fine.
He's just like,
I've been around Themis long enough, and now she talks in code a little bit. She said, let's move forward with tolling.
You code. That's what it is.
All right, I really
It's
appreciate
like
it.
a second base coach.
And we will see you all on Monday, 10
Thank you.
a.m. Thank you.
Thank you.